Good morning, friends. We've got some good news. In addition to the Moderna vaccine rollout and the Pfizer vaccine rollout, USCIS has extended flexibility for responding to their agency notices. Now, you want to listen all the way to the end to know which notice they're talking about. I'm your host, John Ting. I practice immigration law in all 50 states of America and across the world, helping immigrants to live and work in America legally. You may have heard this news before. USCIS created this flexibility back in March 2020, and they've extended it twice. Announcement again, December 18th on Friday, that they're going to extend it past December 31st. So before December 18th, it was going to expire on December 31st, 2020. But now they've extended it another month until January 31st, 2021. So what does this mean? For example, the most common situation that you as an applicant may have received throughout the processing of your application is a request for evidence. Let's say the request for evidence only gave you 30 days and the date on the notice said December 1st, then that means the deadline would be December 30th. Now they do sometimes they give you an extra 3 days on the notice in addition to that for mailing purposes, but our practice in our firm is we always have an internal policy where we set our internal deadline 1 week before USCIS deadline. But anyway, to give you an idea of what this actually means is that it's giving you 60 additional days. Now, because this hypothetical example that says December 1st, that's within a time frame up until January 31st, this allows an additional 60 days. So we'll provide a website down below in the description that we use, a website of a calendar that we use to calculate the deadline so you don't miss anything. This flexibility announcement does not mean necessarily that your responsive documents are due on January 31st, 2021. It just means that if you receive any kind of notice between March 1st, 2020 until January 31st, 2021, then you get additional 60 days. So that's 2 months, but don't take advantage of it. Still, you need to work as hard as possible, especially if you are doing this alone. But even if you do have a lawyer, you need to work with your lawyer. Your lawyer can't do everything for you if you don't give the documents to your lawyer. Because especially for our law firm, usually in this situation, one of the last steps, we need letters from our clients to tell the truth, of course, whether it's about the relationship or how they met, or for example, why they had a legitimate marriage. So you really need to work with your lawyer if you have one. The lawyers can't write the letter for you. That's not how it works. So we mentioned request for evidence. This also includes notice of intent to deny. If you don't know what that means, we have a separate video about that. But basically it is the last straw. It is your very last chance. It's the USCIS saying, look, we really want to deny your case, but we're giving you this last sliver of a chance. Our law firm craves this opportunity to help you. We fortunately knock on wood, we have not been denied. We've been able to overturn that notice of intent to deny to an approval 100% of the time. This announcement also includes continuations to request evidence. N14 is the form. It's usually a one-page document that a USCIS officer could hand to you and your lawyer if you have one at the interview because maybe they just want one extra bank statement for some odd reason. Other notices include notices of intent to revoke, notices of intent to rescind. So that can include, for example, your permanent resident status, notice of intent to terminate regional center. And another more common situation is if a person has been denied their application, you should strongly consider filing an I-290B. That essentially means appeal, but also includes motion to reopen and motion to reconsider. So if you receive a document like that, by the way, you definitely need to speak with a lawyer. Really, in all these situations, you need to consult with a lawyer if you don't have one already. This also includes the N336. This is a request for another interview, essentially, a request for hearing after a person has been denied for the N400 application to become a U.S. citizen. So USCIS won't do anything, take any further action on your case until the additional 60 days have passed. Keep in mind, USCIS is allowing this because on their memo, they're stating that they're trying to protect their workforce. Most people are working remote from what we understand, but at the same time is to grant some flexibility to you as an applicant. But at the same time, please work as hard as you can as if the deadline was only 30 days. This extra time, in my opinion, is we want to take advantage of that if we need some documents for a different country, for example. And I know many government offices in other countries have shut down, and it's very difficult even through the court system to get something completed. So that's what I use the 60 days, extra 60 days for. But in terms of we still internally, that's why people like our law firm, is because we still act as if the deadline is still only 30 days. Friends, if you're new to our channel, please click subscribe down below and click the bell so you get notifications of all our future videos, news, and tips. Smash the like button, and please share this video to your friends and family. We greatly appreciate it. And lastly, please join our Facebook group. It's called Immigrant Guide and Support Living in America. It's a community where people share the challenges and successes on immigration cases. And in addition, people also share their experiences on how they've become acclimated into America. Until next time, we'll see you soon. Friends, thank you for taking the time to watch our channel. Click over here so you can watch our most recent uploads. We'll see you soon.